Welcome to Audit the Audit, where we sort out the who and what and the right and wrong of police interactions. This episode covers probable cause, trespassing, and mental health, and is brought to us by the Reformatoriums channel. Be sure to check out the description below and give them the credit that they deserve. In the early morning hours of October 12, 2021, Pope County, Arkansas resident Corey Jones was doing some yard work on his property using a headlamp and a corded halogen light he had affixed to a tree. A neighbor who saw him working in the yard called the police to report him as a suspicious person, and Sergeant Damon McMillan and Deputy Hayden Saffold of the Pope County Sheriff's Office responded to the call. After discussing the situation with Mr. Jones's neighbor, Sergeant McMillan and Deputy Saffold entered Mr. Jones's property and approached him.
I think he's right there. Yeah. Come here.
I'm not going to go over there. What are you doing? Well, how's it going?
The neighbor called. You live out here?
Yeah. What are you doing out in these woods? I know you hear me.
Yeah, I hear you.
So what are you doing out in these woods?
I'm just hanging out, you know.
Well, you're trespassing. You can't be hanging out.
Well, I'm not trespassing right here.
You're not. Whose property is this?
This is my property right here.
It is?
Yes, sir.
Okay. And what are you doing out here scaring this old lady at 5 o'clock in the morning?
Well, I just figured, you know, it'd be a good time to get started
Get started doing what?
on my work.
What work?
I'm working right here.
You are?
Yeah.
Uh-huh. Yeah, and you live here, right? Uh-huh.
What's your address? Man?
Yeah.
Yeah, if you live out there, we'll go. We're just trying to figure out what's going on.
I understand. What's just...
She's saying somebody's trespassing. Do you live out here?
Yes, sir, I do.
Okay.
What's your name and badge number? I can't quite see it.
It's Hayden Saffold, 1602.
Saffold?
Saffold, yeah.
16. And you, sir?
Do you live out here in these woods or in a house?
What's your name and badge number?
What's your house? Where's your house at?
I was curious of your... I mean...
Well,
Are you not
understand that, and I'll tell you in a minute, okay? I know you're recording me, but you got to understand, I'm asking you a question. Do you live in these woods or do you live in a house?
You guys approached me. I mean, you could tell me.
Right now, I believe you're trespassing until you prove otherwise. You are committing a crime.
Well, is this America? Are we innocent until proven guilty? You're telling me I'm guilty of trespassing right here?
I'm asking you your address because I want to know if you live on this property. Because you could just be telling me that.
I have the Fifth Amendment right. I don't have to answer any questions. I would like to alleviate you guys' worries.
So you can't prove to me that you live on this property?
Sure, I could.
Okay, well then you probably need to do that.
Or you're going to arrest me?
Might have to, yeah.
The officer informs Mr. Jones that he may be placed under arrest if he does not prove that he is the owner of the property. Before we discuss the applicable legal standards further, it's important to note that Mr. Jones was not under any legal obligation to prove that he owned the property or otherwise assist the officers in their investigation. However, it is possible that he still could be legally arrested if a court concluded that the officers had probable cause to believe that he was trespassing. Although Mr. Jones is correct in his assertion that in the U.S. justice system, criminal defendants are innocent until proven guilty, this is not the standard that applies to when an individual can be arrested. According to Section 5-39-203 of the Arkansas Code, quote, "A person commits criminal trespass if he or she purposely enters or remains unlawfully in or upon the premises owned or leased by another person." So, in order for Mr. Jones to be found guilty and convicted of trespassing, a prosecutor would have to prove each element of the offense beyond a reasonable doubt. And because Mr. Jones was the owner of the land, a prosecutor could not meet this legal burden. As the Supreme Court explained in the 1949 case of Brinegar versus United States, quote, "These rules are historically grounded rights of our system, developed to safeguard men from dubious and unjust convictions, with resulting forfeitures of life, liberty, and property. However, if those standards were to be made applicable in determining probable cause for an arrest, few indeed would be the situations in which an officer, charged with protecting the public interest by enforcing the law, could take effective action toward that end. For this reason, the standard for placing someone under arrest for a suspected offense is much lower than beyond a reasonable doubt, and is known as probable cause. While courts have consistently avoided setting a precise definition of what constitutes probable cause, the Brinegar Court explained that, quote, "The substance of all the definitions of probable cause is a reasonable ground for belief of guilt, and this means less than evidence which would justify condemnation or conviction. Probable cause requires that an officer have, quote, more than bare suspicion, and it exists where, quote, the facts and circumstances within the officer's knowledge and of which they had reasonably trustworthy information are sufficient in themselves to warrant a man of reasonable caution in the belief that an offense has been or is being committed. Therefore, if the officers arrested Mr. Jones for trespassing after he refused to prove that he owned the property, it is possible a court could conclude they had sufficient probable cause to make the arrest, even though they would be mistaken about the fact that he was trespassing and he could not be convicted of the offense."
I mean, can you not see that I'm out here doing work?
We can see that, but she called because she's saying that you're on her property.
And I've been out here for 30 minutes yelling, and you didn't come out until now.
Well, I've got to get my kids off to... No, I didn't. I've been back and forth. I've carried some stuff up here to get ready to work.
What are you doing?
I am...
It's not often we get people wandering around in the woods at 5 a.m. scaring people. What I want to know is, do you own this property and what is your address? It's a simple question that I am allowed to ask because right now I think you're trespassing.
Well, I'm also allowed to not answer it if I don't...
So you answering the question could prove you innocent, but you're not going to, right?
I have the Fifth Amendment right, sir.
You have the Fifth Amendment right not to prove yourself innocent. I don't think you want to tell me your address because I don't think you have one, and I don't think this is it.
Well, sir, you're mistaken. Are you going to arrest me for loitering on my property?
No, I'm going to run your name and see what your address is. I have a right to do that because you're accused of a crime right now.
The officer tells Mr. Jones that he has a right to identify him because he is being accused of trespassing. However, a court would likely find that Mr. Jones was not under any legal obligation to identify himself to the officers. The Arkansas Code does not include a stop and identify statute that requires individuals to identify themselves to the police during Terry stops. Instead, Arkansas only places a requirement for citizens to identify themselves in the state's loitering statute. Section 5-71-213 of the Arkansas Code states that, quote, "A person commits the offense of loitering if he or she lingers, remains, or prowls in a public place or the premises of another person without apparent reason and under circumstances that warrant alarm or concern for the safety of persons or property in the vicinity, and, upon inquiry by a law enforcement officer, refuses to identify himself or herself and give a reasonably credible account of his or her presence and purpose." While it is understandable why the officers would think this statute would apply to Mr. Jones in this situation, as they do not believe his assertions that he owns the property, because Mr. Jones was not in a public place or the premises of another person, he could not be convicted of loitering. Further, it is unclear whether the officers even had sufficient evidence to support the reasonable suspicion of criminal activity needed to detain Mr. Jones. Although Mr. Jones's neighbor reported him as a suspicious person, she admitted that she didn't know who owned the property. The officers also did not know who owned the property, and they made no attempts to determine who owned the property before approaching Mr. Jones and demanding that he identify himself. They likewise did not attempt to speak with the property owner by knocking on the door to the house. The only information the officers had is that someone was walking on Mr. Jones's property, and they had no real reason not to believe Mr. Jones when he said he was the property owner. Given the lack of evidence supporting that criminal activity had even occurred, a court could conclude that the officers did not have reasonable suspicion to detain Mr. Jones, which would make the detention unconstitutional.
So what's your name?
So have I not dispelled your suspicions?
Yes or no? No, because I don't even know who you are. Is it a yes or no question, or are you going to tell me your name or not?
If you got to get your kids, you got to get your...
Yes, I do. Am I going to be arrested if I do not tell you my name?
Yeah, probably.
Really?
Because I don't know where you live at, and I don't know if you belong on this property.
Sir, I live right here. I belong right here.
Tell me your address. Tell me your name so I can run it.
I'll tell you my address. My address is...
Okay. I don't know this is your property.
What I would suggest, sir, is maybe you get with her, one of you guys. I mean, if you want to hold me here and detain me, I understand. If you want to get with her and just make sure that this isn't her property, and maybe you're on the wrong...
You can't prove it's yours.
I can prove it's mine.
Then tell me your
I don't
name.
intend to answer any questions.
Okay. Hey, you're under arrest.
I'm under arrest.
Can't find you back.
Yes, sir.
Well, until we know...
Am I detained or am I under arrest?
Right now you're detained until I figure out who you are.
Are you going to release me if I give you my name?
Well, I've asked you how many times you've refused. We're
Well,
going to go down there, we're going to run your fingerprint.
I've also asked you your name and your badge number.
No law says I have to give you my name. It'll be on your arrest report.
Is it not in your policy?
No, it's not.
Was I doing anything wrong?
Yes. You were accused of it, and until I can prove that you're not, by simply giving me your name and I can get your address, we would have left. You're the one keeping me here this long. Because for some reason, and I don't know why, you just want to make this so hard. Why? Are you just anti-government and hate the police? What?
No, I'm pro-civil rights. If you tell me that
last time I'm going to ask
if you tell me that you will let me go, if I give you my identification, I will give you my identification.
I don't know that I should let you go. I really think right now you might have some mental health problems, and I think we might need to go see a doctor.
The officer tells Mr. Jones he suspects he may be suffering from mental health problems and suggests that he's going to have Mr. Jones taken to be psychiatrically evaluated. Under Arkansas law, police officers have the authority to take citizens into protective custody for psychiatric evaluation and possible care under certain circumstances. This is known as involuntary commitment. Section 20-47-207 of the Arkansas Code states that, quote, "A person shall be eligible for involuntary admission if he or she is in such a mental condition as a result of mental illness, disease, or disorder that he or she poses a clear and present danger to himself or herself or others." In order for an individual to be considered a clear and present danger, they must have inflicted serious bodily injury on themselves, attempted suicide, threatened to inflict serious bodily injury on themselves, or attempted to inflict, or threatened to inflict serious bodily harm on another, and there must also be a reasonable probability that the conduct will occur or continue if admission is not ordered. If an officer observes behavior that meets this standard firsthand, Section 20-47-210 of the Arkansas Code allows them to take the individual into protective custody if, now quoting, "immediate confinement appears necessary to avoid harm to the person or others, and transport them to a hospital or to a receiving facility or program for evaluation by a physician." Notably, this statute also allows any quote-unquote interested citizen to take an individual they believe to be a clear and present danger to themselves or others to a hospital or a receiving facility or program to be evaluated for potential involuntary commitment, and therefore does not grant police officers any special authority to evaluate an individual's mental health. However, based on the behavior that the officers observed, Mr. Jones clearly did not pose a clear and present danger to himself or others as it is defined in the statute. And so, if the officers were to take him for evaluation, a court could conclude that taking him into protective custody was an unlawful seizure in violation of the Fourth Amendment.
Sir, if I give you my identity, will you let me
You've
go?
had about 10 chances to tell me your name, and you ain't got it yet.
I also asked you.
I don't care what you ask me. I'm asking the questions, not you. You need to lay it off. The YouTube stuff, because all it's doing is making it worse, man.
The officers placed Mr. Jones under arrest and drove him to the Pope County Detention Center, where they ran his name and confirmed that he was, in fact, the owner of the property and was not trespassing. Despite this, he was processed and written a ticket for obstruction of governmental operations for refusing to identify himself. According to county records, a hearing for the charge was scheduled for December 14th, 2021, and Mr. Jones did not attend or pay the ticket. This resulted in an additional charge of failure to appear, which is a Class A misdemeanor. As of the date of writing this episode, both charges were still pending. Overall, Sergeant McMillan and Deputy Saffold get a C-, because although there is an argument to be made that the troopers could have arrested Mr. Jones for trespassing, the deputies failed to carry out any sort of legitimate investigation, displayed a fundamental misunderstanding of Arkansas's identification laws, and escalated an innocent, non-criminal encounter into an extremely questionable arrest. Instead of reaching out to the nearest homeowner or attempting to verify Mr. Jones's address by knocking on nearby homes, the deputies elected to interrogate Mr. Jones and then refused to believe anything that he told them. If the deputies had taken the time to conduct an actual investigation into the complainant's claims, or made any effort to verify the information that Mr. Jones provided outside of forcing him to identify himself, then this interaction could have had a peaceful and positive resolution. In an effort to curtail the duty of acting as an impartial investigator into criminal claims, the deputies misrepresented the facts of the encounter, made blatantly false claims, and distorted the language of Arkansas law in their favor. At one point in the video, Sergeant McMillan tells the jailer to be sure to book Mr. Jones so that it appears less like the trooper had made a mistake, and it appears as though the sergeant was questioning the legality of his own conduct. Ultimately, the deputy's decision to arrest Mr. Jones was lazy and unprofessional, and this interaction highlights the important role that investigation plays in law enforcement. Mr. Jones gets a B-, because although he could have invoked his right to silence more effectively, he remained calm and collected throughout the encounter, challenged the conduct of the deputies without becoming rude or vulgar, and maintained a respectable balance between complying with the lawful commands of the deputies and invoking his constitutional rights. Mr. Jones offered the officers all the information that they needed to verify whether or not he was trespassing, and it is difficult to fault Mr. Jones for refusing to surrender information that he was not legally obligated to share. It was not Mr. Jones's job to investigate whether or not he was trespassing, and he made a legitimate effort to dispel the deputy's suspicions without compromising his own personal privacy. All that said, the fact that Mr. Jones did not attend his court hearings may have a significant impact on the outcome of his case, and it goes without saying that it is extremely important to be present at any court summons so that you can ensure that your case is being properly handled. If nothing else, I commend Mr. Jones for keeping a level head throughout the encounter and for insisting that his rights be respected. However, I would also encourage Mr. Jones to channel his passion into defending his actions in the courtroom as well. Let us know if there is an interaction or legal topic you would like us to discuss in the comments below. Thank you for watching, and don't forget to check out my second channel for even more police interaction content.